Today we are discussing the case of Messrs Meters and Instruments Private Limited versus Kanchan Mehta. This case discusses about court's ability to close check bounce cases on satisfaction of liability even without the consent of the complainant.
The parties to the case are Ms. Kanchan Mehta, who is the respondent, and the appellant, who is the director of the organization. These are a few facts of the case.
The relevant law to the case are as follows. Section 138 of the Negotiable Instruments Act 1881 states that a person whose check is dishonored due to insufficiency of funds in that person's bank account shall be deemed to have committed an offense and shall be punished with imprisonment up to 2 years or with a fine which may extend to double the amount of the check or with both. Section 147 of the Negotiable Instruments Act 1881 states that notwithstanding anything contained in the Code of Criminal Procedure 1973, every offence punishable under this Act shall be compoundable. Compoundable offences are those that can be compromised, that is, the complainant can agree to take back the charges levied against the accused.
In the case, since Meters and Instruments Private Limited was ready to make the payment of the check amount, even if Kanchan Mehta declined to accept the demand draft, the court can close the case on satisfaction of liability even without the consent of the complainant.
As per the judgment given by the court of law, the guilty must be punished at the earliest as per law, and the one who obeys the law need not be held up in proceedings for long unnecessarily. Since the offence is a civil offence and does not contain anything in the Code of Criminal Procedure, as per Section 147, the offence punishable under the Act shall be compoundable. The court promptly closed the case in this situation, with Meters and Instruments Private Limited having to pay only the check amount and any costs to Ms. Kanchan Mehta.